And we're live. So, Jesse, first of all, thank you very much for agreeing to do this. I have a channel with a few thousand viewers, and it's very nice to have the access. Very welcome to have the access to talk to you directly about this, hopefully we can answer some of the questions. They may be questions that I know what your answers will be, but it's just helpful to get the questions down. And hopefully this will help people that are trying to make a decision. So I have a list of questions. I'm going to put them up on screen as we go through, and we'll go through. So first one is just to introduce you a little bit, because somebody might not know who you are. So just give us a little bit of of your background as an introduction, your DV, diversity visa pedigree, your previous work for DOJ, that sort of stuff.
No, and thank you, and it's actually a pleasure and an honor to be here. I was recently the former director of litigation at the American Immigration Lawyers Association. I'm now in private practice with Wasden Banas, but I knew you. You sent, I think, an email to me at AILA when we had this class action in Gomez that actually was based on Trump's ban. And we had a class of diversity visa applicants. We had a class of relatives. We had a class of employment-based non-immigrants. And we only won for the diversity visa class because there the judge recognized, and this is the Gomez case, the judge recognized that this is a specific set of people whose lottery ticket runs out at midnight on September 30th. And from there, we were able to save, they did 9,000 visas, I believe, in September of 2020. And then, and then not only that, we were able to get these visas extended because President Biden did not repeal the proclamation. And now, though, we're sitting here in January 20th, 2022, and we're still waiting on 9,095 visas to issue. And the reason that's important, I guess, for those of you who are winners of this year's lottery, is that they actually are ordered to issue those visas this year on top of the ones that you all deserve. And so, but before that, I do want to say, I started my career for the Attorney General's Honors Program as a trial attorney. I worked as a prosecutor in the District of Columbia. I worked for a judge. And then I worked at the Office of Immigration Litigation for close to 14 years. And I did everything from gang cases to class actions. So I don't always do diversity visa cases. I'm a federal litigator. Okay. So thanks.
Yeah. So you were the enemy.
Yeah. Well, I'll tell you though, you say that, and people who've heard me speak before is I have to know my enemy, right? It helps me know my enemy. It's actually, but I mean that in the nicest way possible, because I actually know a lot of the government attorneys personally.
Exactly.
And I think in our case that we're going to talk about today, it provides a tremendous advantage for me. It did when I was at AILA. And not only am I former DOJ, but everyone at our law firm, all four of us are former DOJ attorneys. And it actually helps because they know us, we know them. And, it's just a thing that we use as a kind of a cap. Yep.
Yep. So okay, that makes perfect sense. And I think I'll probably come back to a couple of points you raised there. I do want to just quickly divert to the Gomez case since you raised it. It was tremendously helpful. Like you say, during that September rush, there were thousands of visas issued that would never have been issued. Then Judge Mehta agreed with you that those should be protected once those visas had been expired. Both those things were extraordinary. I mean, they were amazing. Frankly, I remember when we first started discussing this, and you and I were sort of first discussing the Gomez suit around about, I think, April of that year. And Curtis Morrison was also discussing that. I remember arguing with Curtis that the discussions that were happening were like a snowball in hell chance of coming off. So I'm thrilled that you guys managed to make that work. So, and I was happy to have helped. But there is a small group of people left who were people that were issued visas in probably before about March 20th of 2020. They were issued visas. They expired. They were not part of the class in Gomez. They were part of the class in the ACCA case, which became part of the class in Gomez. But we still haven't really got a resolution on that. They're still unclear whether they can be processed or not. So at some point in your capacity as Gomez, on the Gomez case still, perhaps that's something that we can clarify with the government, because there are still those people who've paid all the fees, paid the medicals, got their visas, and couldn't travel because of the various travel problems through COVID at that time.
Yeah, I mean, one point though, before it goes to show you though that as much as I push, I'm a litigator and do litigation, but as we saw today, that I think it was a couple days ago with what they're doing for the poor people who are subject to the travel bans, allowing them without fee to reissue, that is a type of fix that I think where litigation is not, there was obviously the Hawaii case in the Supreme Court, but that's something where the government can always do the right thing. They don't need us to be yelling at them and doing these court things. But I do agree with you. The reason they could not be a class member in our lawsuit is that our class was defined and certified based on those who were subject to the April ban and not before that.
Exactly.
And so it's a technicality, but if anyone deserved a visa, it was those people, right? They had it, they were there, and then this ban comes out and they're cut off. Yeah, exactly. So anyway, good. So let's move on. So let's talk about the DV2022 lawsuit. Let's just quickly sort of cover deadline for sign up, your fees, and the parameters that you consider important for that. If you can just quickly go over that. Yep. So we're going to onboard until January 25th. We're going to file February 1st. The timeline is critical. Our fees are $21.80. It's a flat fee. It covers FOIA litigation. It will cover any appeal. And really, I think the biggest question besides the fees, and I understand that, I appreciate that. And the reason we need to be paid for our work now is there's really no way for us to collect after, and there's no way to can't really chase people. And if people didn't want to pay, they don't have to pay. And I've been on the subject other end of that. But the reason filing in February is critical is that we don't have to do this type of extraordinary relief. We can raise these issues now to the government, and they can either agree to work with us or they can agree to fight us. But we should know now. And we're not going to go for an injunction. And so it's too early maybe to go for an injunction, but it's not too early to file a lawsuit.
Right.
And the reason for that is that we'll have a 60-day window after we file where I have no problem saying this. I'm going to call the government. I'm going to say, listen, number one, I need every single one of my plaintiffs to be made whole, meaning they need to be granted what they deserve, which is an interview. And number two, what is going on? Because we have less than 400 visas worldwide being issued. We have no interviews. And then we have these consular specific issues that are ridiculous. And so I think it actually, it's not why now, it's why later for me. And I know there's a difference of opinion in that. And I want to say right here, I respect all the attorneys who give their time and attention to this issue, because diversity visas is the one visa that expires. I know you all know that. But if anyone, it's also congressional intent that you all should be here, okay? And it's an incredible law that should be defended. And that's why we do this. And so I'm not going to sit here and say that everyone has a bad strategy. What I'm saying is that's our strategy. And the other thing I want to mention is that is just something I need to do, and something I do is that we are limiting the number of plaintiffs we'll take on to no more than 300, and that may be a bit high actually, but the reason we're doing that is I need to have a personal relationship with the clients. That's I wouldn't do it any other way. And that's not, again, it's also part of a strategy, because I think it helps us if the government wants to negotiate and they only want to negotiate for our plaintiffs. It gives me the ability to say, okay, we'll take care of the 300 people then, and we can move on. Because that's as much as I love this program and I'll defend it, and I have defended it for over almost 3 years at this point, I will do everything to make sure that my clients for DV 2022 get what they need, which is an interview, and the sooner the better.
So let me pick up on a couple of points from what you just said. So going backwards, if you reduce the price, you would get more plaintiffs, but you would have less time to work for them personally, less time to look at their individual issues and that sort of thing. And you don't want to do that, right? So it's not a criticism of large lawsuits and or small lawsuits or one-to-one representation or whatever else. It's just literally, this is the strategy that you want in order to price appropriately for a right-sized lawsuit, in your opinion, and what you want to do in terms of providing the personalized service, right?
Yeah, and so let me explain how we did it, because we've known about this. We've been talking since December, and the partners and I reached a discussion. We actually looked at this and we said, if we rolled in the costs to do a FOIA litigation, meaning we're going to file a FOIA, and if they don't give us the information for our clients, we're going to actually add that to our lawsuit. And if we add it in an appeal, okay, and let's say our hourly rate is $400, but that's what we would charge someone, to do one of these cases by the hour. What do we need to cover our costs and the costs of our staff, because our staff need to get paid and everything else. And so we actually looked at, so everyone said, wow, how'd you come up with 2180? Well, we actually broke it down by how much it would take to cover our costs, not make money, just cover our costs. And so that's why. And I know it is higher, and right, you would get the efficiencies of scale if you opened it up. And that was a tough choice for us to make. But I actually, and I'll give my colleagues at the firm credit. I said, I only want to do a small group. I only wanted to, I put my foot down. So that's kind of where we landed. We had to make some sacrifices there.
Yep. Yeah, that's clear. That's understandable. I just put up there, you mentioned FOIA litigation, FOIA Freedom of Information Act. So you intend to ask the government for information where necessary on specific issues, and you set up a formal request each time they have to answer. Is that correct? Or
yeah, and they only have a limited amount of time to answer. And if they don't answer, you can actually go to a federal court and file, and we will. Right. So we can amend. And here's what it does. And again, I know this is probably, I don't want to make this too much of a public, but it doesn't hurt to have that as part of your negotiation with the government, to say, you could go do all this work, and go review all the documents that you already have and give them to us. Maybe we have some of them, maybe we don't. Or you could just give someone an interview, right? Do the right thing. And so it's part strategy, part we want the records for, it's not for us, right? It's for our plaintiffs. They deserve anyway to see what their own records say, and maybe bring them and review them prior to their interview. So that's a benefit there. But number two, it's also, we can agree not to do this, and you could just give them the interview. And so, yeah, it's part of our strategy.
Yep. Got it. Okay, good. You also mentioned injunction, but I think I'll come to that later, if that's okay. People have asked me to explain some of the legal terms that might be used, and just so I'll do that during the call. Okay. One of the things that you'd mentioned in terms of the parameters was the case number parameter. Why have you established those numbers, and will you accept a case that is above those numbers that you've put in there as a parameter?
So we actually had those, and we actually dropped them once the new visa bulletin came out. Okay. And so we don't have a case number parameter anymore. And there's a couple of reasons for that. Number one, I always reserve the right to be open-minded and flexible. And the visa bulletin caused me to change my position. Here's why. And there's a couple of reasons. Number one, The visa bulletin didn't move, which I thought was egregious, and it reflected a very big issue that is going on that I don't have the answer to yet, but I know there's a problem. And number two, and you've seen this, and we've talked about it, and we've posted, and everyone's seen it. They're interviewing people who don't have current numbers, and they're issuing visas to people who don't have current numbers. And so why would I limit who I can help if the government is doing this? And that's why I dropped those case perimeters. Now, okay. But here's an important point, though, and I know you get this question, and I get this question. Can you help me change the bulletin, or can you help me change my number or make my number current? I cannot do that. But what I can do is, number one, explore what exactly is happening out there. And again, this is all about position sizing. So if your number is your number one, and if the government were to follow its customary and I would say legally required manner of processing, I cannot make them issue a visa to someone who's not current. Now, we already just said they did it. So maybe I can, but no. But if you have a high number, your number's your number, your position's your position. A lawsuit could increase that position. It's not gonna give you a right to an interview. I can't guarantee that you'll get an interview. I can agree that I can make your position better, but the number is the number.
Yeah, good. I had a question lined up for that for later, so I've just put that up there and you answered it. Thank you for that. Okay, good. Yeah, we'll probably touch on, so you and I see the visa bulletin progression a little bit differently, and possibilities for the lawsuit to change that. I actually more or less, in my own way, I'm kind of cautious what I say, because people come back to me every single time. You said this, you said that, and usually they misquote me. So, you know, but the day before the visa bulletin came out, I explained to people why movement on the VB wouldn't happen, or, you know, might not happen. So it was somewhat predictable, frankly. It is, it's understandable, not that it's acceptable, but it's understandable. And so we need to be a little bit careful with sort of understanding, you know, why that goes on, etc. But I can address that later, maybe. Okay. You answered this in the Telegram earlier, but which court, which judge, and expected timeline? We touched on the timeline, but I'll come back on that. Which court are you going to go to? I know you can't choose the judge, but
yeah, well, we're not going to disclose that, right? We're going to keep that to our clients and those, and part of it is because we have a number of people who have signed on, and I'm obligated to them. I don't want to release too much information because I need to work for their best interest, and it may be in my best interest to release that information, but it's not in their best interest. And I always operate in their best interest. But I can touch on the timeline because this is a question that we get quite often. And so February 1st, we're going to file. And then after that, the government has 60 days to answer. What they'll most likely do if they don't want to work together, which I pray they do, but if they want to fight us, they will try to dismiss the case. They always do that. Instead of answering, they're going to try to dismiss it. I've written what we're going to file for the most part. I did a lot of writing today, actually. Our goal is to obviously have it. If we thought it was going to be dismissed, we wouldn't file it. So I think we have good grounds. I think we're ready to go. But after that, we would have to engage in briefing, because we don't want to be in a reservation posture. And so we want a decision in August. And so that's why we'll have that, you know, if you 60 days, okay, March, April, we can brief this and then have it on the judge's desk for a ruling, so that he or she can rule and actually issue, maybe if it required it, our 300 plaintiffs interviews in September. We know they can do that.
Yeah.
And so we don't have a situation where we have to ask for a reservation.
Yeah. Again, goes back to your strategy of not having, say, 10,000 cases that need to be interviewed, all of them in September, because, you know, that would just be unwieldy and it would force you into a reservation situation. So it kind of helps to explain your strategy about keeping it small. Okay, so my next question you kind of just touched on, which was the strategy for the suit, including the negotiation phase. What I mean by the negotiation phase is me as a non-lawyer figured out this, I guess. In order to get the government talking to you, you need a lawsuit, right? But after the lawsuit, there's the 60-day phase, and that I'm calling the negotiation phase. You may call it something differently. But that's where you're hoping that you can get them to the table to just see sense, sort of put the FOIA requests in, and hopefully say, let's make this go away. Let's make a deal. If that doesn't happen, then we're going to court, and the arguments in court will take place, and the judge will take a view, which you're hoping to wrap up by August, you're saying. And that timeline makes sense. Is this more like the Go case in terms of going for summary judgment, or is it like the Good Luck case, which has been on a longer track because of the different strategy there? Which of those two cases is it like? Do you know what I'm referring to? The Go case under the impact litigation team, that case is finished. It's ended, apart from the appeal. Whereas the Good Luck case was destined to take longer anyway, just because of how it was filed. Right? Are you filing the first way or the second way?
You know what? You just cut out on me. Can you just say that one more time?
Oh, okay. Sorry. So I'm trying to compare to the Go case, which had a fairly fast, fast in some terms, fast finishing date, as opposed to the Good Luck case, which was always going to be ending in April anyway. That was sort of laid out months ago. So are you filing in the way that will get you to a fast sort of August timeline specifically for that reason? Or, how are you dealing with that? Is it more like Go?
Yeah, we're coming back from September and looking at this at what's the time we would need, because we don't want to put pressure on the government. We don't want to put pressure on the court. And so what's the best? I mean, a lot of these cases would normally take much longer than 8 months, 6 months. They would probably take, a year and a half, especially now. So we're already on kind of a quick pace if you look at a federal case overall.
Yeah.
So it actually is probably more like Go. It's actually in it more, but it's not. It's going to sit on its own shoulders, because I think now what happened was in years prior, maybe there was an injunction motion filed early. And we're not going to do that, meaning that you ask for relief immediately and then kind of proceeded. We're actually going to take this, 60 days. Maybe we learn on February 3rd that no one's willing to talk to us, and then we have to fight it. But we want to make sure, one of the things we learned, we want to make sure that we don't have to ask for reservation of visas unless it's the last option. Because what I've seen is how difficult it is for the government to actually go forward and issue those visas. And for our clients, they don't want to be 2 years from now waiting and wondering. It's not in their best interest. And so, like I said, I gotta do what I think is best for them. And what's best for everyone is to get an interview like June and move, right? And right. Get your, and so that's really the catalyst.
Okay. I saw a comment, by the way, on the landing page about September 15th being sort of a cutoff. I just wanted to make clear there are cases, people have asked me this, there are cases that are issued even on September 30th interview dates. They did always have the ability to do that because they can approve the case on September 30th in local time zone, but actually print the visa in the next 2 or 3 days after that.
Can I tell a quick story? Because this is amazing. So it wasn't a client, but last year at my position at AILA, there was someone who actually filed for an adjustment of status, meaning they were in the United States. And the person emailed me frantically and said, the consulate in Johannesburg has a document and they haven't sent it to USCIS yet, but the person is at the interview and they're shutting down. They're gonna close. And I had to get on, and when you're at AILA, you have privileges, and God bless them because they're great at what they do. And they actually scanned it so that they could approve it prior to closing on that September 30th. Wow. So It just goes to show you they can do a lot of things until the clock strikes midnight.
If they want, exactly.
If they want, yeah.
If they want to, yeah.
Yeah.
Okay. I've seen you talk about you might add some clients later. You might have a later onboarding, but there would be a higher fee for that. Can you just talk about the strategy for that, or have I got that wrong?
Yeah, it's only going to be until February 1st. I mean, one of the things so why the higher fee? Well, because essentially it takes work to review and add plaintiffs. And so we have to charge for our time with that. So it's not a matter of like a penalty or, right. We want everything to be in place because we need it to be perfect for February 1st. And so, but I also understand that what always happens in our lawsuits, what always happens in the ones I've worked on is people say, oh, I didn't know you were closing it off. As you know, you say it 1,000 times. And so I didn't want to shut the door. The only way I will shut the door either before January 25th or before February 1st is if we hit that maximum number.
Right.
But we're not there. We're not there. And I don't want to pretend that we are. We're not. But I don't think, but after February 1st, I'm not going to do that.
Okay. It's probably, from what you just said, it's probably behooving on me to ask the question, is there a minimum number? Is there a chance that you don't file? Let's say you only had 5 people.
No, I mean, no, we're above the minimum.
We're above the minimum. Okay, good. Yeah. Thank you. What's you've already answered this, but I just want to sort of address the second part of this. You've got a strategy to have a small number of clients. We discussed why, but isn't a big number of clients or plaintiffs more powerful to the judge? Some people would wonder about that. Just briefly address that one.
I think so, and I think we've seen those cases have success. Curtis has had success. I mean, he knows what he's doing. Absolutely. My number about the smallness is not so much, is more for me to manage and have a relationship. It's not, but the other part of the strategy is if the government wanted to do away with me and not listen to me, call them all the time and email them, they could. It's easier for them to obviously grant 300 interviews than it is to grant thousands, right? They could make us go away, and they've done, and they'll do that. They'll do that. Right. I'm not saying they'll do that here, but they've done it in the past. Right. So, and I just want to give an example because everyone's like, well, give me an example. Well, here's an example. Our law firm, actually, I was at Ayler at the time, brought a lawsuit last year for spouses who needed work authorization and they couldn't get it in the United States. This is a delay in the government. And we started off with, I don't know what the number was, but we're like down to 3. After a little bit, because so they just kept making the people go away because once they give you, an interview in the visa, we really can't do anything, right? You drop out. So is it easier for them to make us go away, whether they agree with our lawsuit or not? Absolutely. And this is where my government experience comes in. I will tell you, is it fair? Is it right? I don't know. I'm the government attorney. I'm not looking at the name. I'm calling up the consulate and saying, hey, his number is 171 from, Germany, scheduled for the interview. What's going on? I don't want to deal with him because, and this is where, let me raise this other point. If you have a low number, this is one of the reasons why we welcome you and are offering refunds to people who get interviews right away, because I know if I were the government person, I'm going to sit there and I'm going to do the numbers, assuming they are going by the numbers. And if I see someone with a number of 171 in a region, I'm going to say, okay, we got to fix this now because this makes us look very, very bad. And so what will end up happening is they'll whether they tell us or not, they're going to pick off our best plaintiffs.
Yeah. I saw that in September of 2021 and 2020. They even reached out to a couple of people that were not documentarily qualified. They DQ'd them immediately and set up the interviews because they were low case numbers. So I know it happens. You're absolutely right. Okay. You can't guarantee a win, not going to ask you to. But do you feel that you can offer something the other lawyers can't? And if so, explain why.
Well, I mean, again, I'd like to say that lawyers who are operating in this space are not competitors, they're colleagues. I've worked with them, whether it was in 2020 or in other matters. They have a product that they have, and what they offer. So I don't, it's not for me to sit here and beat my own chest and sit here. I just, part of the strategy that we have is that I will have that personal touch with my clients. I think that makes me better. That's what I do. I love that part of the job. It makes me perform better. So if that's something that's different, I don't know what other people have planned, and I don't want to talk about them. I just, for me, my track record, I think I don't need to talk about it. It speaks, whatever it is, good or bad. I think for me though, I'm maybe I'm just different anyway, but the other lawyers are good people. I mean, I don't want to sit here, and I'm not going to talk poorly about what they do and who's better and who's not. It's not about who's better. Okay. I think the point of this whole thing is this: instead of talking about which lawsuit when, it's what's the best decision for you. Okay. And I don't want to sit here and talk about, because honestly, if it comes down to lawyerly skill, we don't have the strongest case. Right. I don't believe, listen, I need to be at my best every day, but to win on this with the facts I think we have, it's really about who you trust, and it's always about who you trust. And so I think everyone's doing good work. So
yeah, I'm going to ask you that question about how to choose. No, I agree with you. I work with Curtis and Raphael. Raphael doesn't like me for some reason, but I work with them anyway. And then the Impact team. Other than those three, you, Impact, and Curtis and Raphael, I haven't worked with any other lawyers, so but I'm sure there's some good ones out there. But I don't recommend any others because I don't know any others. So
I will say this though, one other thing, and this is important because people need to understand. When I left AILA, and I was the first person they hired, God bless them, as to direct a litigation program, and I had the opportunity to work on a number of big lawsuits, class action lawsuits. The reason I chose to leave and join Wasden Bannis is because the attorneys we have there I just think they're the best in the world. And I got to leave and go join a good team. So I feel like if for me, it's a little bit like getting to work with Michael Jordan or, Ronaldo. I got to go join kind of the best there is. And I will say that I do believe that. And I'm lucky to be there and earn the respect, and they gave a lot of trust because they are allowing me to do this. There's plenty of work, and they've said, if this is something you're passionate about and you want to go do it, they're allowing me to do it. But the people I work with at Wasden Bannis are the best. I mean, they are so super talented. Cool. So it's an honor. Yeah. It's really fun.
Very cool. Can you touch on, I don't know if you can, but can you touch on the specific strategies for embassy specific cases? Which embassies do you think you can tackle and how might that work? Can you go into that?
Yeah. So, I mean, you have your own, I don't want to say a bad word. So in case my children look at this, but we know that there are consulates who are doing zero and at the same time having no flexibility to transfer cases. And so when I drill down, whether it's Kathmandu, Addis, I think Jordan, Cairo, Sydney, there's too many, Ghana, right? And there's just too many to do nothing. And I know we live in a world of COVID, and I get that. But we've also saw them in September 2020 issue 9,000 so they can do it. They are at a pre-pandemic level of immediate family immigrant adjudications, which require interviews. And so they're getting to those. And there are reports that they're still following this tiered approach. And whether it's consular specific or not, there's no excuse to have known about COVID and the problems and develop a pilot program and do all these things and still not take care of people. They can't have a situation where, let's say, all the visas get issued in Japan and none get issued in Ghana. That doesn't make the system right. And so, yes, we're going to shed a light on that and explore that and say, if we can negotiate, let's find alternatives. And here, I actually, one of the lessons we can take away is a lawsuit has the ability to get them to move, because Curtis and his team did great work for getting the consulates in Baghdad and Kabul. And so Curtis has my absolute, he did a lot of great work there. He took 25 people and he changed the entire policy. And that's one down, and we got about 40 to go as far as I'm concerned. So litigation works. Okay. But yeah, so we have a macro problem, right, with KCC and spitting out interviews. And we also have embassy level issues where they haven't even turned the lights on at some embassies for these poor, for diversity visas. And it's not good enough. Yeah.
Okay. So I know you're attacking one particular embassy in particular. Those are separate lawsuits, right? They're individual lawsuits.
Yeah, so we're taking that. There's a Sydney specific problem, and that we're leaning into that as a specific issue. I can discuss it a little bit, but they have an issue where they plan to move 2 years ago, and you turned me on to this. They planned to move 2 years ago, and they didn't accommodate. And number one, they didn't do it in time, and number two, they never thought about the diversity visa program that has a sunset date. And so in that situation, it is going to be like a one-off separate situation where we're going to try to go in there and hammer out a deal and get OC moving, because they're doing nothing.
Yeah. Okay, cool. So Sydney you're doing that for, but obviously working on a single individual consulate, it's a smaller group of people, therefore it can be higher cost, etc. So it's not like you can do that for every individual case, as it were.
Well, it raises an interesting point. People, again, not to beat this drum, but people always ask this question about how do you come up with fees? And we usually have to charge by the amount of time it takes. And so when we look at the fees, of course, if I were to do a one-person suit for someone who's seeking their own diversity visa, I have to charge them much, much higher, right?
Yeah.
Because I have to give them, if it's a group of 100, I can do more there. If it's a group of 20, that's different. And so we do, and that's another reason why I can't keep the lights on and charge at some future date. There's no way to do that.
Right.
And so I know people don't like that answer, but I'm not going to sit here and tell you differently and say that, we can do payment plans or anything like that. I'm not like Visa, where I can extend credit and pay you, and you can just pay me at a future date. I'm not Visa. I wish I was, but I'm not.
Right. Yep. That's clear. Thank you. You're not filing a PI, right? Because some other cases that went for PI failed in that respect. You're not applying for a PI. Is that right at this point?
And let me just explain what a preliminary injunction is. When we say PI, preliminary injunction is this. You have to, at some point, there's a reason you need emergency relief. And if you don't get it, you'll suffer irreparable harm. And so sometimes you file it at the commencement of a lawsuit, right at the beginning. And you say, I'm going to get thrown out of the United States, or I'm never going to get let in the United States. That's called irreparable harm. And you need to prove that right at the beginning. And you actually also have to show that you have a likelihood of success on the merits, meaning your case is definitely, not definitely, but, likely to win, or there's a really big question involved. The public interest totally supports you. The government is doesn't have equities on their side. And what it really does is it compresses the timeline to like 14 to 28 days, where you actually have to go through like almost like a mini lawsuit, and the judge has to rule. The reason why we don't want to do that now, and in fact, I don't think it'd be good practice, is we can solve this. We don't have irreparable harm now, right? Because we'll have irreparable harm in September. And here's the other part. we can file. You don't have to file it just in the beginning. Irreparable harm can happen or be about to happen later. So if I'm in September and the judge is golfing and he doesn't want to issue a decision, I can force it by filing later. I can file what they call a temporary restraining order or a preliminary injunction, but I don't need to play that card in the beginning.
Yeah. Okay, cool. Very good. Okay. So a couple of quick questions here. Can you force an embassy to open if it's closed? Necessary. Let's take one of the embassies that's closed for political reasons, for example, like Cuba.
Yeah, no, absolutely not. I think what I can do, and not guarantee, but what I can work on is a flexible solution, like we saw with Kabul and Baghdad, right? Yeah. The government can move mountains if it wants to.
Yeah. Yeah. So the second part of that question is, can the lawsuit force KCC or the embassy to reassign to another embassy? That's essentially the strategy for a closed embassy, right? And
I'll tell you right now, for all my friends in the government who are listening, it's a lot easier for them to make the decisions than have a judge make the decision, right? Because the judge, he's just going to look at he or she's going to look at a map. That's why the government, I really do hope, recognizes the issue, recognizes the problem, comes to the table. Will they? Well, probably not, but they should. And we're going to give them the time to do it and say, listen, where can we put people from Ghana, right? Where can we put people from Ethiopia? And let's work on that. We have time. We have 7 months, and let's get a solution. And that this is, maybe I'm too optimistic that we can pull this off, but I know I can't pull it off if I start in August.
Yeah. Good. Okay, so we've talked about the current thing. So a sort of follow-up to the current thing is, and this is the discussion, you said that you think the lawsuits could cause pressure on the government and cause some movement in the VB. Can you explain that a little bit more?
I want to start by saying, can we move the visa bulletin? No, we're not going to move the visa bulletin. We're not asking them to say, make everybody current. My theory, and I need to be cautious with this because we have kind of visa bulletin on the brain, everyone, and I recognize that because everyone's looking at the numbers and they're quite low. What I think is, and again, it speaks to thinking like my enemy. If I were the government and I opened this lawsuit and I looked at the visa bulletin and I looked at the worldwide numbers and I looked at the evidence that we've issued visas to people who aren't current, I would say, it's not Charlie anymore, but I would say, get the new Charlie on the phone because the judge is going to really ask some really tough questions if these numbers don't go up. And so what would I do? That's what I would say. I would say, get me the new Charlie and get these numbers to look better because, and I think it's going to actually cause more scheduling and more visa issuance because they can't look this bad. They cannot be on a 2,000 per year pace, right?
Right.
Which is what they're on. And I'm going to tell you right now, okay, will our lawsuit cause that jump? I do believe that with all my heart because they can't sit there and defend themselves otherwise.
Yeah.
So that's kind of my theory. I don't mean to say that I can make OC go from 850 to 1,600. What I'm saying is the government's going to take a look at the lawsuit because they're not concentrating on it right now. They're not looking at it, right? They got everything. They got the border issues. They have Afghani issues. They got Russia and Ukraine. Okay. They'll open this lawsuit. They'll pay attention to it and they'll say, yeesh, we've only done 400 visas. What? And they'll say, oh, pilot program, this and that. And they'll say, listen, this has to look better by June.
Yeah. Okay. People will ask, so I'll add my point to it. I don't disagree with what you just said at all in any way. I think that you can actually cause some increased activity through the lawsuit, and that might even reflect in the VB. I don't think we can force them to go current if the math doesn't work. They may go current anyway because basically, I believe last year they kind of threw their hands up and they said, okay, we're going to go current. And I understand technically why they went current in 2020 and 2021. So, so I get that, but going current is not what you're talking about. Faster movement of interviews or faster movement of the VB to allow faster movement of the interviews is what you're talking about being caused through the lawsuit action. I think that's probably, and I agree. I think that's probably true. Okay. You've answered this already about the fees being too high, but you were at Ayla, and everyone famously was, when a few months ago, people were saying no more lawsuits. Everyone was like, no more lawsuits. Everyone was blaming me, by the way. They're either blaming me or they're blaming Curtis or they're blaming the lawyers. No more lawsuits. And now obviously they're interested in lawsuits because they can see what's actually happening. But people expected Ayla to sort of ride in as the white knight and do a pro bono case, and you're associated with Ayla, right? Can you explain why you can't work for nothing?
Yeah. So
you have a mortgage to pay, I presume.
Yeah. Well, now, yeah. So Ayla is not involved, and Ayla has a lot of, there's a lot of immigration issues that are in need of great fix. There are delays everywhere, and Ayla is asked to litigate every case. I mean, when we took on Gomez, and we're still taking it on, 3 years later, we put in, I think I did I don't know how many hours, 1,000 hours maybe. And so, and we had it wasn't just Ayla, it was Ayla, the Justice Action Center, a law firm of Mayor Brown, who are probably one of the most prestigious law firms in the world. And so I'm no longer at Ayla, although I'm staying on for Gomez, and I'm doing that pro bono now, actually, the appeal. So I'm not, obviously I'm in private practice and I'm not, charging Ayla or anything. But I think why Wasden Banis cannot do that is, we have to get paid for our work. Otherwise we go bankrupt, right? I mean, we can't. And the other thing is this, we get to choose what cases to take. And we have other work that we could choose. And so one of it is, we're charging this as the lowest fee that we would ever offer anyone. Yeah. So some people say low bono, and it really is, because quite honestly, for the amount of work that anyone who operates in this space, and you see me on Telegram, and you should get compensated for your time, right? It takes a massive amount of time to manage this type of lawsuit. It's not easy. This is not a easy case. And it takes an incredible amount of hours. And it would probably be in my best business interest to do another case, but I'm not. And so what we've done is we've come up with a calculation that will be able for us to cover our costs. Yeah. And that's where that fee is. So
yeah, I like the term of low bono. That makes sense. That's good. I agree with you. I think people from other countries don't realize how expensive it is to have a lawyer in this country represent you, because the fees are charged at American rates. Even if you happen to live in, I don't know, Ethiopia, where the average salary is maybe $3,000 or $4,000 a year, it doesn't translate over here. It still costs people money in American terms, etc. American education.
Well, and let me just say, one thing about that. I think one of the most challenging things for me to go through this onboarding process, and I've talked to my wife, and actually I have two 11-year-old boys, twins, who get to listen to Dad. It's hard. I don't like the conversation. I don't like to tell people no. And when I was at Ayla, I didn't have to do that, and It's new for me. But it's part of the job, and I need to do that. But I also need to be fair to my staff, and I need to be fair with everyone who I represent.
Yeah, and your new relationship with Wasden Banis as well. I mean, you've agreed to work for them. That doesn't mean causing them a bunch of free free work.
I'll make them bankrupt. Yeah.
No, and to be clear, I don't work for nothing. I work in a day job, and I get paid nicely out of my day job. I do the DV lottery stuff for nothing because I've got something that pays the bills. I couldn't do it for nothing if I didn't have that other job, So anyway, do you think this suit will benefit non-plaintiffs or plaintiffs of other cases, perhaps?
Well, yeah, I think we spoke about that a little bit. In a perfect world, the government would say, yes, this pilot program, super, it just dismantled the system. How do we come to a place where we can stop all the lawsuits and protect the program for this year? That would be amazing. I don't expect it, but that's one way it would benefit non-plaintiffs. The other way would be is if our lawsuit does something less, but similar in the sense that it triggers the government to take a hard look at the massive problem we have, where we're at a pace that's prior to 2020 right now. Right. And so this goes back to our conversation about the bulletin and the number of visa issuance and scheduling, where they may say, regardless of whether they fight us or not, hey, make us look better so we can win before the court. So that's another way. But I will say this, as much as I hope that happens, I need to do whatever I need to do to get the people who I represent what they want, which is an interview. Okay. Yeah. That's my number one focus. My focus at AILET was the class. Here, it's actually great because I can take everyone individually. I can negotiate on their behalf if I have to. And quite honestly, I've said this before and I'll say it again. Once I win for the plaintiffs, I'm out. I just want to take who trusts me. I want to win for them. And I can't really waste energy on other things until that happens.
Right. Yep. Cool. Last question, Jesse. I know I've taken a lot of your time already. I appreciate that. How should someone choose which lawyer to engage? Right. How should they make that decision? It's a tough choice, and I'm not going to tell people which way to go. So how would they do that?
I would say, do the homework. Don't just rush off and make a quick decision. Look at the lawyer, do a little bit of research on the background. If you can talk to them and then having a one-on-one engagement with them, maybe that's a way. That's usually how, we get hired, is I'll have that. It's all about what suits you. I don't want to make it as easy as choosing where to eat dinner, but there's a lot of options. Maybe it's on the menu. I can tell you though, everybody who works in this space has different personalities, but their hearts are in the same place. I can only speak to what I like to do. And I'm willing to talk with whoever wants to work with me until we close on January 25th. But they should choose. People need to choose who they trust, who doesn't keep them up at night. And again, it's a personality fit, and it's a skill fit.
Yep. Cool. Thank you. Jesse, are there any questions you'd hoped that you would be asked, or is there anything you feel we haven't touched on?
The only thing I'll say is this, and I know you get this, and sometimes we all get a little frustrated. But number one, what you do is incredible, and I should have said that. So it should have been the first thing I said when I sat here. I think anybody who has worked in this space comes to learn about its benefits and gets so passionate about why it's not working. And if you're a winner in this year's lottery, you can get high stress and high anxiety. And I want to tell everyone that I'm not in your place, but I am sympathetic to where you are. And I've had to live with that through clients, and we all have. But I will say one of the things I'd like to see on social media and videos and everyone else is being kind, because we're kind of all rowing in the same direction.
Yeah.
Nobody wants to win and have someone lose. That's lawyers. That's DV2022. Maybe we just want the government to lose a little bit, maybe. But even the government, right? We can fix this. And I just think though that we need to have, like I always say, like good vibes or positivity. We have a ton of time left. Okay. It doesn't seem like it, but we do. And I want people to appreciate your great work, because no one is better at this than you. I rely on you. And that we don't need to be nasty about it. We don't.
Yeah. Yeah. I need to learn that. Or remember that as much as anyone else as well. I've got a mean streak in me, and I tell my daughter, we've got to be nice.
Yeah.
So yeah, you're absolutely right. But yes,
we're all getting better every day.
Yeah, exactly. We're all a work in progress, right?
Exactly.
Yeah. All right, Jesse. So thank you so much for your time. Thanks for everything you do. And thanks for continuing to represent the DV2020 folks as well. Appreciate all your hard work on that. So good luck for this case, and I hope you're successful.
Well, I appreciate that, and I know we'll be in touch. And if I can ever help you or anyone out there, let me know. I'm available.
Yeah.
Okay.
I should tell people the story of my citizenship interview. I half expected one of the government lawyers to burst into the USCIS office during my interview and say, no, we're not giving him citizenship. And so you were kindly on standby there just in case I needed to call a lawyer.
I told you, I also have a mean streak, and so I only let it out in court. So
yeah.
Yeah.
I want to know that guy who said I wasn't an expert. I want to know who he is.
Yeah, we'll fix that. We may have to fix it. We may fix that soon. Okay.
Yeah. All right, Jesse. Keep well.
Be good.
All right.